He Thakur, Hon'ble Kumar Thakur, Sir, Banaras University, Professor Hung Soo Kim, Professor Law School, Korea, Professor Vajranayan, faculty members, scholars, staff members, students, ladies, gentlemen. It's indeed my privilege to address this August gathering on this occasion of seminar where we have assembled to rekindle our thoughts on 75 years of parliamentary democracy in India, retrospect and prospect. And of course, to rededicate ourselves to the noble ideals which gave us independence and which are always the guiding lights in all our endeavors. Before I switch on to a few points which I wanted to make, I was with a great amount of great feelings of energy of the learned speakers before me. I was getting involved. And I could notice what Ajay Kumar indicated, that the reasons for choosing this topic for the seminar has essentially been that of these 75 years, we have sweet memories and also some not so sweet or even sore memories too. Certain challenges too, as indicated by Shri Thakur also in his address. Professor Ajay Kumar indicated a few of the areas of our concern, including the positioning of governors vis-a-vis the chief ministers or the persons of elected governments, like some states like Kerala, Punjab, Delhi. Professor Vajranayan indicated that we need to remind ourselves as to whether Hon'ble or not. Professor Kim, we are so grateful to you having given us insight into the democracy in March in Korea, and particularly the different phases of democracy Korea has gone through. Shri Thakur, of course, indicated he felt his presence here to be homecoming. He also indicated a few areas of concern. And probably this sealed envelope, Band Lifafa, was the last significant point Mr. Thakur made and indicated about how the Supreme Court declined to accept Band Lifafa or the sealed envelope, particularly when any matter is requiring transparency in all its forms. While yes, so far the functioning of the judiciary is concerned, as we always know, the court meets an open court. The presentation of the thing is always here can be done, etc. But friends, when we have an orderly society and various norms of progression of the society, democracy particularly we will be talking about, in those norms, it's not that band lifafa or the sealed envelope, the closed envelope, is always a prohibition or always a denial. On the contrary, you all are, a lot many of you, the students and the professors are here. Well, I will just remind all of us that so far as your examinations are concerned, particularly when there is an examination paper which is to be given to an examinee only at the appointed hour and not before that. It has to, per force, go in a sealed envelope. It cannot be made known unless we transform the entire examination system into an open system or an open book system. There are certain examinations which are held like that too. There are several such things which, for the force of requirement of a larger good of the society, they could be divulged, they could be shared at the opportune moment, at the appropriate moment, with the appropriate persons. Say, for example, presentation of the budget in the parliament. Well, for the force of the very job, for the force of its requirements and its implications, it need to remain in confines. It need to remain not known until there is a time to be known. Friends, my point only is that whenever we as the students of law will keep on reminding us that whenever there is a particular principle, whenever there is a particular norm, where there is a particular way of doing things, well, the checks and balances, the requirements of and exceptions, the requirements, different requirements according to the needs, according to the particular setup or setting, is interwoven in those workings. Therefore, we do not, as the students of law, will look at anything, particularly when we are dealing with the human beings in the civil society, anything in absolute form or anything like having no exception or no room for modulations. So, but yes, I respect what Mr. Thakur has indicated, that so far as the courts are concerned, well, this is one of the fundamental norms that yes, everything has to be open and transparent. When a particular party, who is always, everybody is equal before the court of law, is to present anything to the court, it has to be with all openness. Other side, as also, the entire world must know as to what is being presented. But again, I would remind myself again, if I have closed a matter for judgment, and my judgment is to be delivered, unless that judgment, until the time that judgment is delivered, it will remain within confines. So the confines are not unknown to the orderly working of the things and systems. Changes and several serious changes have been indicated, and rightly so. The requirement, the promises right at the beginning when we started had been to make it sure that the person last in the corner, the person who is unknown, faceless, voiceless, gets the voice, and is an equal participant in our democracy's working. Yes, these are the promises, these have been the promises, and we in 75 years, well, first of all, need to appreciate how much we as collectively have done. Of course, we have to do a lot. There would be requirements, constantly requirements, with the shifting paradigms of the present days. The requirements are of rapid progression, and the requirements are now rapidly expanding themselves, rapidly altering their shapes also. But we as a well-knit society, I will be just coming to that. Fraternity, this is one particular fundamentals of our constitution, our society. We have maintained it. Come what may and whatever had been our differences, whatever might be the differences, we as a country have maintained that fraternity. And that has been the reason. Just an example of that had been the challenges thrown by the COVID-19 pandemic. We collectively dealt with it. Of course, there were losses. Of course, there were such challenges, such unknown challenges, for which none in the world was ready for it. We dealt with it collectively. It had been that collective conscience and also the capacity to act collectively. Well, that is one of the hallmarks of Indian democracy. We all are not only proud of that, but yes, we all are a humble servant of that hallmark. And that is how we progress. Before entering into other things, well, I'm reminded of those great lines of Hon'ble, which were recited in the Constituent Assembly also when they took up the task of preparing a document that would be our lifeline, that would be the heart and soul of this country. When it was recited, and we keep on reminding that, and it is rather interwoven in us. When Hon'ble said, कुछ बात है कि हस्ती मिट्टी नहीं हमारी, सदियों रहा है दुश्मन दौरे जहां हमारा. कुछ बात है कि हस्ती मिट्टी नहीं हमारी. That is what we are, and that is what we would always be progressing. That is what we would be dealing with. Friends, respect for the rule of law and a well-developed judicial system, underpinnings of a democratic society and a modern economy. Democracy is not only a form of government or a framework of collective governance, but it's a system and process which organizes the social life of individuals. If considered not solely as an instrument of government, but as a rule to which the entire society, including the government, is bound, the rule of law is fundamental in advancing democracy. What we are, friends, is succinctly stated how we were shaped and what we are and what we would be. Well, an insight we can take from the opening passage of the introduction on the website of the Supreme Court that reads as follows. India, I am quoting, India has one of the oldest legal systems in the world. Its law in jurisprudence stretches back into the centuries, forming a living tradition which has grown and evolved with the lives of its diverse people. India's commitment to law is created in the constitution which constituted India into a sovereign democratic republic containing a federal system with a parliamentary form of government in the union and states, an independent judiciary, guaranteed fundamental rights and directive principles of state policy, containing objectives which, though not enforceable in law, are fundamental to the governance of the nation. This one paragraph broadly gives us a fair idea as to how India has been constituted into a republic, democratic republic. What are its ethos? What had been its roots? What it aspires? And what it proposes? Friends, dharma, or the rules of righteous conduct involved as a solution to the everlasting problem that arose from the man's natural instinct or desire for physical and emotional enjoyment, wealth or material blessings. On being questioned by Yudhishthira on the meaning and scope of dharma, Yudhishthira said in the Shanti Parva of Mahabharata, and its translated version is, Vishnu said, it's most difficult to define dharma. Dharma has been described to be that which supports the upliftment of living beings, thus that which guarantees welfare of living beings is surely dharma. Vishnu stated that the people who are diverted from the path of dharma due to sensual desires, passion and greed, and stronger people begin to harass the weaker one. As a remedy to this, the threefold ideals of dharma, artha and kama were laid down for the welfare and happiness of the people, and the fourth ideal being moksha, or the desire to secure eternal happiness, that was also prescribed. And the king was entrusted with the responsibility of enforcement of dharma. Even though this term dharma has such a broad meaning that it encompasses all rules, such as spiritual, moral and personal rules, as well as civil, criminal and constitutional law, it in fact gives precise meaning depending on the context. For example, when the word dharma is used to refer to the giving of one's wealth for a public benefit, it means charity. When it is used to refer to giving of something to a beggar, it means alms. When it is held that in a given case, dharma is in his favor, it means law or justice lies in his favor. When it is said that it is son's dharma to look after his aged parents, it means duty. When it is said that a debtor's dharma to repay a debt to the creditor, it implies legal and pious obligations. This very dharma, when used in the context of king's duties and powers, it refers to large dharma, and we can definitely equate it with constitutional law. Friends, dharma is, though intrinsically interwoven in every fundamental concept of a civic society, yet, as regards the rules of governance, there is little or perhaps no evidence on the formation of a representative parliament or any such body of governance, though one would find some such concepts as being that of a benevolent monarch, as propounded and exposited by Kautilya in Arthashastra, Thakur was referring to Kautilya's various expositions. It is seen that in our chronicle history, even without a nation state, the experiments in this part of the civilized world with representative governance started way back mid-6th century BC in the form of republic, the Tanrajya, like the erstwhile kingdoms of Lichuni, Parva, Kapilavstu. We can definitely, for our learning, equate the modern day parliaments, cabinets, and prime ministers akin to the sabhas, samitis, and dharmatis of those republics. Friends, according to the Smritis, the institution of kingship was established for the purpose of administering justice or enforcing dharma. All the Dharma Shastras and Smritis agreed that dispensation of justice was the highest dharma of the sovereign. Rather than elaborating on the various features of the actions based on dharma, perhaps this one narrative would remind ourselves of the sanctions and supremacy of dharma, and also the potential and power of the people where judicial ethos were put to test. The narrative is of a case decided in 1774 AD by Ramashastri, the Chief Justice to the Peshwas in the India now falling in the state of Maharashtra. The narrative is like this. After Peshwa Madhavrao died on 18 November 1772, his only surviving younger brother Narayan Rao, who was 17 years of age at that time, succeeded to the position of Peshwa. His uncle Raghunath Rao, who was greedy for power, saw this as an opportunity and devised a plot to depose Narayan Rao. In execution of this plot, young Narayan Rao was assassinated on 30th August 1774. And Raghunath Rao assumed power as Peshwa. The Chief Justice Ramashastri investigated Narayan Rao's murder and he found the accused, Raghunath Rao, and 49 others, including a woman, guilty of murder and sentenced them to death. This decision was conveyed to the ruler, Peshwa Raghunath Rao, because Raj Dharma granted the king the authority to determine the quantum of punishment, as well as to have it executed. The Peshwa took no action because he himself was the first accused in the case. The Chief Justice kept insisting that his decision has to be carried out. As a result of this insistence, Raghunath Rao dismissed Ramashastri, the Chief Justice. He quietly retired to his village. Dharma, on the other hand, asserted its supremacy, as the narrative goes, through none other but the people. The people refused to recognize and acknowledge Raghunath Rao as Peshwa because he was found guilty of murdering Narayan Rao, the lawful heir. After Raghunath Rao was deposed, a council of 12 people known as Barabai that was formed to take over the administration. This case, friends, is a constant source of inspiration, a glowing tribute to the supremacy of Dharma, the rule of law, the independence of judiciary, and the exemplary conduct of a judge, but above all, the power of the people who refuse to recognize Raghunath Rao. We have had in our systems, this is when we are talking, well, since we are just taking stock of, in retrospect, from where we started, what are our roots. There are a few, these narratives, these features need to be always with us. In this very setup, we need to remind ourselves that we have a well-defined legal system in this part of the world, where there were different kinds of courts, like the courts of Kul, that is the family court, Shreni, that is the court of the council of trade or profession, Gana Court, Gun Court, that is the assembly of the village, Adhikrita Court, the court appointed by the king, the Sashita Court, the court of the king himself, and then lastly, Rip, that is the king himself. The second one was the court of king, and lastly the king himself. When we understand and when we examine our constitution, and when we see lastly the power reserved with the President of India to grant pardon, we can definitely correlate with our Indian history as to how these powers, from where and what is the source of those powers. Switching on, friends, to the years later, as we know, after not many years, different rulers, different princely states, different parts of British India, ultimately when independence of India was in the offering, then serious deliberations began to ensure that the new nation, it shall have its own charter, drawn up on the noble ideals handed down by our progenitors while looking towards the horizons of hope, expectations, and aspirations. When our Constituent Assembly that began its work much before the appointed date of 15th August 1927, took up this task of framing the Constitution of India, it had to traverse through a great many challenges, which included the challenges related to accession of the states, nearly 562 princely states being there, and a document was required to be drafted which ought to be acceptable to all. Partition itself has thrown so many challenges with lots of lives being lost. The Britishers themselves, the erstwhile rulers, well, they contributed their part in creating so many problems, including destroying of the manufactured goods and our industries, and even the land, in the name of land reforms, we were having so many systems in place. We were, rather than reforming or rather than being of use, they were the instruments of exploitations. Then there were diversities. The India, this geographical area of immense diversity, significant cultural, linguistic, regional, caste and other distinctions. These were serious challenges. There were so many other challenges. The Constituent Assembly set together to begin their task. On 22nd January 1947, Dr. Rajendra Prasad, chairperson of the Constituent Assembly, read out the resolution before the Constituent Assembly, which had been the resolve, I would say, for the Constituent Assembly. It had been the resolve then, and it remains the resolve ever. And I'm tempted to quote what was read on 22nd January 1947. The resolve was this: the Constituent Assembly declares its firm and solemn resolve to proclaim India as an independent sovereign republic and to draw for her future governance a constitution. This is a job day. But the promises were wherein it's said, wherein the territories that now comprise British India, the territories that now form the Indian states, and such other parts